All right, this is cause number CR 21-1029-173, the state of Texas versus Alexis Perry, set for discovery status.
Judge, I showed discovery was filed on December 20th.
And an offer.
She does have an offer, Judge. We've extended an offer for a PTI.
And I've reviewed the discovery. I believe I have everything, and I've extended the offer to my client.
All right, then, Ms. Perry, then the court deems discovery status is held. Your next court date is pretrial. That is March the 9th at 9 a.m. So stay in touch with your bondsman and your attorney. We'll see you back in March unless y'all work it out soon. CR 21-1117-173, the state of Texas, for arraignment. Court notes clear not guilty for to wrap up both of them. All right, well, here's what I'm going to do. I'm going to set this new case for March. What do you want to get? So both the cases, I'll set them again for discovery status. 130. Christopher Smith. All right, these are cause numbers CR 21-0091, 0092, 0789, and 0893. State of Texas for Christopher Smith. The offer been all right, then, Mr. Smith, the court deems discovery status is held. Your next court date is for pretrial. That's March the 9th at 9. So as soon as you receive your reset, sir, you can have a seat. Can we handle it now since I have everybody on? I'm going to handle it now because I finally got Zoom up and running. Can y'all hear me there on Zoom? Can y'all hear me on Zoom? Give me a thumbs
I
up
can-
if you can hear me.
I can barely hear you.
Sorry, you can barely hear me?
Correct. And we have our volume turned all the way up, Your Honor.
How about now?
That's better.
Okay. It'd help if I had my microphone put where it's supposed to be. Right, which case is this? Is that Mr. Allison we have with us here?
That is correct.
All right, I'm gonna call it then. This is cause number CR 18-0233-392, the state of Texas versus North Allison. That is fit for a hearing. Mr. Smith.
Yes, Your Honor, just preliminary. Mr. Allen. Back in August 2020.
Yeah. I do, Judge. I'm gonna have three. State have anything to add to that open? Okay. All right, and then who are you witnesses? Those individuals either.
Your Honor, we're not able to hear you,
You can't hear me right now?
just barely, and I couldn't hear anything the attorney was saying.
Do you have the battery? All right, let's change the battery in the microphone. Y'all give me just 1 minute.
No problem.
Is that better?
Yes, thank you. And also, Dr. Botch just pointed out, we think the attorney may be muted, so maybe that's why we can't hear.
No, he's not. That's actually, can you say something, Brian?
Hi, Chandra. Can you hear me now?
Yes, perfect. Okay.
All right, let's see if we can't allow to multi. There we go. All right, I think we have everybody now. And so basically,
Chandra, I was just informing the court of the preliminaries and that the hospital had filed the application for outpatient services. And then I would be calling the three of y'all as witnesses. That's what y'all couldn't hear.
Okay, thank you.
all right, your witness.
I would call Chandra Burnham, Your Honor.
All right, Chandra, if you could raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
That you can lower your hand. Mr. Schmidt, your witness.
Thank you, Judge. State your name to the court, please.
Chandra Vernam, that's spelled Chandra, last name V as in Victor, ERNUM.
And Ms. Burnham, you are Mark Allison's social worker there at Terrell State Hospital. Is that correct?
That's correct.
And you've been working with him for how long?
Approximately 1 year.
Okay, you said 1 year. Is that correct?
Correct.
Okay, and Ms. Burnham, you and I have had several opportunities to talk about this application that the hospital's filed, correct?
Correct.
And Mr. Allison was initially at, he wasn't initially at Terrell State Hospital, is that correct?
That's correct.
Okay, where did he come from?
North Texas State Hospital.
Okay, and after he was found not to be manifestly dangerous by the review board, he was transferred to Terrell State Hospital, is that correct?
That's correct.
And since that time, has he been medication compliant?
He has.
Okay, now he did not respond particularly well to some of the medications. We won't go into great detail on those, but it's just physically, but most recently, what sort of medication, psychiatric medication is he on, and how often is that given to him?
He's on a long-acting antipsychotic injectable by the name of Haldol Decanoid. He receives it every 4 weeks.
Okay, so the Haldol injection lasts for 4 weeks and is capable of treating his mental illness for the duration of that time, correct?
Correct.
And since he's been at your hospital, has he had any sort of aggressive or has he acted out in a violent manner or anything of that nature?
No, he's not had any kind of aggressive or violent acts the entire time he's been here.
Okay. Is it your opinion that at this time, does he pose a significant risk of serious harm to others if he's released under the plan that y'all have proposed to the court?
I do know that concerns have been raised in Dr. Ho's violence risk assessment. However, I do believe as long as he remains medication compliant, that risk is minimized.
And Dr. Batts can testify to this, but is it the consensus of the treatment team that he's reached a maximum benefit at your hospital?
That's correct.
Okay, and what exactly does that mean? I mean, that term is used, but what does that mean in lay terms?
Sure. That ultimately it's the treatment team's belief that he's no longer truly benefiting from being here in the hospital. He's been here for approximately 1 year. That entire time he's been stable. He's been free from psychotic symptoms. And his participation in some of the rehab classes has decreased over time, but some of the clients feel that the classes are very repetitive with a longer hospitalization. So we're not really offering him any additional treatment he hasn't already received.
Okay. With regard to the plan that y'all set up, it's not that Mr. Allison would just simply be released out to the streets. Is that correct?
Correct.
You all have a comprehensive plan where he would be referred to the Child and Family Guidance Center in Dallas, Texas for outpatient services. Is that correct?
Correct. I've collaborated with them throughout his hospitalization.
And that would be essentially a group home. Is that correct?
He would live at a group home, and then he would receive the highest level of services provided by the clinic, which is their assertive community treatment team.
Okay. And otherwise known as the ACT team, they would supervise the outpatient plan and make any necessary changes to his medication.
Correct.
They would monitor his compliance, correct?
Correct.
And they would immediately notify you all and the court, if so ordered, if Mr. Allison was refusing to take his medication or otherwise being non-compliant with his outpatient treatment program.
They would not traditionally notify us at Terrell State Hospital, but they would notify the court.
Okay, they would notify the court. And of course, the court would have the ability to immediately issue a warrant and have Mr. Allison brought back before the court if there was a concern that he was not complying with the outpatient treatment plan.
That's correct.
Now, the plan is laid out in some detail that the court has had an opportunity to read, so I'm not going to go over all of that. But do you believe that with the support of his mother, who has been involved in this process, as well as the treatment plan that some 6 of y'all have signed off on, that this would be in the best interest of Mr. Allison, as well as safe for the community, assuming Mr. Allison continues with his medication?
That's correct.
Thank you, Ms. Burnham. I'll pass the witness.
Mr. Cox?
Ms. Burnham, can you hear me?
Yes, I can.
Okay. Ms. Burnham, would you agree if he's released from Terrell State, there are no guarantees he would be medication compliant?
He has been compliant with his medication since he's been here in the hospital. And of course, Child and Family Guidance can provide that reassurance of him remaining compliant. And if he isn't, the court would be notified immediately.
Okay. I believe you also stated, Ms. Burnham, that his risk for reoffending in a violent manner is minimized. Is that correct?
Correct, as long as he remains on his medication.
Okay. As long as he remains on his medication, the risk is minimized. But there's no guarantee there's not going to be another violent offense. Would you agree with that?
It's hard to say because I have known him for a year and he's not been violent that entire time, but I can't guarantee that a violent offense would not occur.
Okay. And Ms. Burnham, are you familiar with the facts? On this underlying case for which he was found not guilty by reason of insanity?
I am.
Okay. And would you agree that was a very violent offense?
It was.
Okay. I'll pass the witness.
Nothing further for this witness, Your Honor.
All right, next witness.
Call Dr. DP Vats. Bats or Vats? I'm sorry, doctor.
We can't hear. Can you say something, ma'am? I think you're muted.
Hello?
I got you now. All right, if you'll raise your
Okay.
right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you, doctor. Your witness, Mr. Schmidt.
Thank you, Judge. Would you state your name to the court, doctor?
My first name is Deepti, Deepti. Last name is Vats, Vats.
And Dr. Vats, thank you. You are a psychiatrist with the forensic program at Terrell State Hospital. Is that correct?
That's correct.
And you are a treating physician for Mark Allison?
That's right.
And how long have you been treating Mr. Allison?
Since 9th of March, 2021, so approximately 11 months, exactly 11
Okay.
months.
And does Mr. Allison have any acute symptoms of mental illness at this time?
He does not.
And he's currently on this injectable Haldol medication, which is given to him approximately once a month. Is that correct?
That's right.
And has that medication been successful in managing his mental illness?
Yes, we have not noticed any symptoms of psychosis. He has not mentioned any delusions, does not hear voices or see things, hear things that other people don't. For as long as we've had him on the forensic unit, which is from March of last year.
Okay. And you've, Dr. Vats, you filed a physician's certificate of medical examination for mental illness that I believe was before the court. Is that correct?
That's right.
And in that, you believe stated that the proposed patient has the ability to participate in outpatient treatment services effectively and voluntarily. Is that correct?
That's right.
And you indicated that Mr. Allison is at a quote baseline with his symptoms and is inclined to continue treatment in the community. Could you state what in lay terms, what the term baseline means?
That he is at baseline, he's not experiencing any symptoms of mental illness, and is at the best possible functioning level.
Do you believe that he has achieved maximum hospital benefit at this time?
Yes, yes.
Are you familiar with the outpatient management plan that has been put together by the number of individuals who worked towards this?
Yes.
Okay, and do you believe that Mr. Allison, based upon your treatment, conversations, and prescription of medications to him, can be successful on this plan if he is medication compliant?
That's correct. I believe that.
Okay. And has he resisted medication at any time, receiving medication any time during his stay at Terrell State Hospital?
He has not. He's never refused to take it.
Okay. And do you have any concerns that he would refuse to take it if he was managed through the ACT team on an outpatient basis?
Well, I guess there's always a likelihood of someone coming off their medications once they feel better or out in the community. But being on a long-acting injectable, I think we catch it early because they have to go to the medical clinic to receive it. And if they don't show up for that appointment, we know that they're not being compliant. Instead of just medications or pills, which it's very hard to keep track of if they're being compliant or not. So I think this long-acting injectable that he's on ensures compliance.
Okay. And so the long-acting injectable is something that would be a safer alternative to the community than him, say, taking pills once a day and perhaps hoarding them or something of that nature. And then, I'm sorry. Yes, ma'am.
I'm sorry. Yes, that's right. I don't mean to interrupt.
No, and so you are also in support of him being released to an outpatient program under the supervision of the ACT team with the understanding that the court would have the ability to immediately issue a bench warrant if Mr. Allison was non-compliant.
That's right. Yes, I'm of the same opinion.
Thank you, doctor. I'll pass the witness.
Mr. Cox?
Dr. Vatz, I believe you testified that Mr. Allison at this time does not have any acute symptoms of mental illness. Is that correct?
That's right.
Okay, but he has been diagnosed with mental illness. Is that right?
That's correct.
What's his diagnosis?
Schizoaffective disorder, bipolar type.
And this facility in Dallas that y'all propose he go to, it's not a lockdown facility. Is that correct?
That's not a lockdown facility, yes.
Okay, so he'd be free to leave if he wanted to.
That's right.
Okay, I'll pass the witness.
Nothing further for this witness. Call Mark Allison, Your Honor.
Thank you, ma'am.
Thank you.
All right, Mr. Allison, if you'll raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can lower your hand, Mr. Schmidt.
Thank you, Judge. Would you state your name to the court, please?
Mark Anthony Allison.
Okay, and Mr. Allison, you're of the understanding that the hospital is recommending that you participate in this outpatient program that we've been discussing under the ACT team. Is that correct?
Yes, sir.
Okay, and you and I have had a chance to talk about this program on at least one occasion in the last couple of weeks. Is that correct?
Yes, sir.
Okay. Now, Mr. Allison, you understand that the concerns that the state and perhaps the court have regarding releasing you on an outpatient program, given the nature of the offense. You understand that, right?
You want me to take my medicine? Ain't that right, sir?
Yes, and that was my leading into my next question. You're on a long-acting injectable Haldol medication, as was stated, correct?
Yes, sir.
How's that working for you?
I'm totally comfortable with it, sir.
Okay. Are you willing to continue taking that medication since it would, of course, be ordered by the court if you were released to this outpatient facility?
Most certainly, sir.
Okay. And what are your goals, Mr. Allison, if and when, and it will be a when at some point, but if the court releases you to this ACT program at this time, what are your goals?
My goals are to get back in the oil field, get my back a little healthier, and just remain humble and start my life over again, sir.
Okay. You do have some physical issues regarding some discs in your back. Is that correct?
Yes, sir.
Okay, and you're hoping to get some treatment and or surgery on that. You've been getting physical treatment on that at the Terrell State Hospital. Isn't that true?
Yes, sir. My neck and my back.
Okay. But your goal is to get out and get back to work. Is that correct?
Yes, sir.
Okay. Have you been compliant with all of the treatment and as well as your medication regime there at the hospital?
Yes, sir.
You understand that if the court released you to this outpatient program that is recommended by each of the parties at the hospital, that in some sense, the court's taking a big risk on you. You understand that?
Yes, sir.
Can you ensure the court that, in your own words, that you would be compliant with the program if the court released you to the outpatient care under the supervision of the ACT team?
I can promise you that you have nothing to worry about as far as any kind of psychotic episodes or anything of that nature.
Thank you, Mark. I'll pass the witness.
Mr. Cox, anything else?
No, I rest, Your Honor.
Mr. Cox for the state?
Nothing from the state, Judge.
All right, y'all want to close? No recommendation, just closing?
Judge, I would ask that the state's application, excuse me, not the state's, the Terrell State Hospital's application for outpatient services be granted. I mean, the goal of the hospitalization is to get people to a point to where they can adequately function in society. And while, you know, schizoaffective disorder and bipolar disorder may not have a cure, it certainly has a treatment and a treatment that's working very well for Mr. Allison. He's complied with all his medication. He's had no violent episodes since he's been hospitalized. And he is willing to comply with the terms that are set forth, which I think are very comprehensive and well thought out by the hospital. I can also state that in the report that the court has the option of ordering Mr. Allison also to be supervised by an officer from the Henderson County Community Supervision Department, so that there's another layer of protection for the community, so that that officer can at the very least check in with the ACT team to make sure, at whatever basis that the court chooses. I mean, you have total flexibility here to make sure that Mr. Allison is complying with all of the things that are set out as far as the medication regime, as far as the psychiatric treatment that will continue if you allow him to participate in this program. And so I think there are layers of protection here for the community. And so I'm asking the court to grant the hospital's application and allow Mr. Allison to participate in this program as is recommended by the physicians, the social worker, and the superintendent of Terrell State Hospital.
Thank you, sir. Mr. Cox?
Judge, this is a particularly violent offense. As the court heard through the testimony, there are no guarantees that Mr. Allison is going to be medication compliant. The facility for which it's proposed that he go to is not a secure lockdown facility. He'd be free to leave. Your Honor, the state still has concerns that Mr. Allison poses a danger to the public and to the victims in this case, which were his brother and sister-in-law. So we're asking the court to deny the request.
But when he was, thank you, when he was original, well, do you have anything to follow up on that? I guess it's your burden.
Judge, other than that, there's always those risks. I mean, in every case.
There's a risk with all of us, right?
That's right.
But
Not all of us.
not all of us have, are, been found not guilty by reason of insanity for
Sure.
particularly violent offense. I will note, however, that this was an agreed not guilty by reason of insanity. And just so I can procedurally, so we can kind of get on the same sheet of music. So under 46C 261 of the CCP, is this kind of a dual hearing? Like this is the review, the yearly review, or is
Actually,
it not?
it's not, Judge.
But the yearly review would be
Sometime prior to March 23rd.
not later than 30 days before. So could we not consider this? Because if I don't, what's going to end up happening, if I do find by a preponderance of the evidence that inpatient commitment is suitable, wouldn't I just have to turn around again in a month and have this hearing again?
So yes, actually, Ms. Burnham and I did discuss that, and I did discuss that with Mr. Cox. I think that the court has the jurisdiction to, on its own merits, if the court's going to deny that, to do a renewal of inpatient commitment. And some courts have done that in the past. I mean, I don't know any case law on that or anything to that effect.
Well, what if I don't mean to cut you off, but what if I did find by a preponderance of the evidence that treatment and supervision, I'm just to say it straight from the statute, that treatment and supervision can be safely and effectively provided as outpatient. If I found that you've proved that by a preponderance of the evidence, then I still have to have this hearing under 46C261 to renew that. Is that correct? And I'm going to have to do that within a month.
I see what you're saying.
So if I found it, then a month I could check on it.
Absolutely. I was not understanding what you were saying. I thought you were saying if you denied it, could you then turn this hearing into a review of inpatient commitment? Yes, absolutely. I mean, every year you
Right.
review it anyway, Judge. That
And I
is
have to
correct.
do it not later than the 30 days before it expires. And it looks like I signed the order for inpatient commitment on March 24th of 2021. So, okay. Anything else then? All right, well then, under Article 46C, .262, the Code of Criminal Procedure. Well, first of all, the court has in its possession the physician's certificate of medical examination, and the court's going to take judicial notice of that, as well as a letter from Terrell State Hospital indicating its opinion, and basically based upon the testimony of the experts and the doctor, that they believe that Mr. Allison could be safely and effectively provided with outpatient treatment. And the court finds that that has been proven by a preponderance of the evidence under 46C.262, and is ordering him to receive inpatient treatment and be supervised by the ACT team.
I guess it would actually be technically outpatient.
Did I say inpatient?
You did.
I meant outpatient.
Yes.
I'm ordering him to be transferred to outpatient supervision, again, based upon the expert testimony, and that he be supervised by the ACT team as well as a member of the court's community supervision department. And so I'll sign that order. I'm also ordering him to adhere to the medication protocol that has been established for him by the team. And then Kevin, can we go ahead and get a date right now?
March 23rd.
So if you look at 46C.261,
I think I have to do it for 30 days, right?
So there is that is true, although there's no provision that triggers any sort of there's no automatic provision of release if the hearing's not held within that 30-day time period.
There's
Judge.
not even by case law.
There's not.
Okay. So what I'll do is then the year anniversary is March 23rd. 20, is it 24th? I think I signed the order on the 23rd. Can you look and see, Sandy? When was the latest order to continue inpatient treatment? That's on the docket
I
sheet.
think it was March 23rd of
I think it was
2021.
too. Yeah, I can see it. No, March 24th, signed order. So do we have a date a little sooner than that, like a week back from that? Let's do a few days before that.
The 21st, which is Monday.
All right, so I am going to set this March the 21st at 9 a.m. For a hearing on renewal of orders. And at that time, I think the court, if the court continues his inpatient or outpatient treatment, the court would have to find by clear and convincing evidence that it's basically still necessary. Is that correct?
I believe so.
Yeah, I would think so, Judge.
Okay, and I think that provides a safety net. So, you know, the doctors have recommended this. We'll transfer him to inpatient. In March, we'll have the hearing that we have to have. I
Outpatient.
keep saying that, outpatient.
Yes.
In March, we'll have another hearing, and it'll allow us to check the status, and that's our statutory required hearing.
Very good, Your Honor.
All right, I hope all that made sense.
So you all will need an order, correct, Ms. Vernon?
That's correct for outpatient services.
Okay, we'll get to, I'll get back to the office and get going.
Okay.
The March 21st at 9 a.m.
Yes, sir.
Okay,
And that's for the statutory hearing on renewal.
thank you, Ms. Vernon. Ms. Vernon, I'll give you a call in a few minutes.
Perfect. Thank you, Your Honor.
Thank you.
Thank you all. Appreciate you waiting through our
Thank you.
technical difficulties there.
Yes, sir.
You need a break or you good? Okay. All right.
Judge, I'll get an order going.
And I'm going to end the meeting now. Thank y'all. Y'all are released.